In five, four, three, two, one.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner. And on behalf of Judge Stafford and Judge Bennett, we welcome you, Ms. Wade, for this oral argument. You will be the only party presenting an argument today, since the appellee, Starr Anastasia Potts, has not filed a brief. So there will be no need for you to reserve time for rebuttal, and you may use up to your entire 15 minutes in your singular argument. Unless there are some announcements, Mr. Hibner, please call the case.
Cedra, Deanntre, Potts, Taylor versus Starr Anastasia Potts.
Ms. Wade?
Good morning, Your Honors.
Good morning.
Good morning. So this is a case about two same-sex people who were married in June of 2015. The history of the case is this. My client, Cedra Potts Taylor, her name is now Taylor, and Starr Potts entered into a civil union back in 2008. Now, in 2008, gay marriages were not legal in the state of Georgia where they were. So they had no choice but to enter into a civil union. However, in 2015, Obergefell passed, and 3 days after the Supreme Court made gay marriages legal, they got married. Prior to getting married on June 28, 2015, the parties entered into a contract with the with a reproduction company. I wouldn't say infertility because my client is not infertile. In 2013, wherein the parties agreed that they would harvest my client's eggs, inseminate them inside of her body with a donor sperm. Starr Potts and Cedra Taylor signed a contract in 2013. Now, in that contract, there was a clause in there that said, we don't give you any advice about parenthood status. And they both signed that. It's in the contract. And I also extrapolated that and put it in my brief. Well, the parties then subsequently moved to Tennessee, and the marriage deteriorated. And my client, Cedra Taylor, filed for a divorce. When she filed for the divorce, she claimed in her complaint that Starr Potts was not the mother of the children. The children were born on July the 10th, 2014. They did not get married until 353 days later. Starr Potts, in her answer to the complaint, stated that she was the parent, basically citing de facto parenthood, saying we agreed to have these children back in 2013. We signed a contract with a reproduction clinic, and therefore, by default, basically de facto parenthood, I should be the parent because I held the child out to be mine. Well, my client's lawyer at the time filed a motion for summary judgment, basically saying that the Tennessee state statutes do not allow Starr Potts to be a parent because she had no biological connection to the children, and the children were not born within 300 days of the marriage. Starr Potts' attorney, on the other hand, relied on the holding out, which the statute says if a man holds a child out to be theirs, then he can say that he's the father. And then he also relied on de facto parenthood. The judge did an order, summary judgment order, and said, these issues are too complicated to decide on summary judgment. So I request that you all have a hearing, preserve the record, so the Court of Appeals can make a decision about what we should do, because the statute is void on how to deal with this type of situation.
Well, it's my understanding the trial judge denied the summary judgment because it was a complicated legal issue, but he felt that the factual foundation should be fleshed out more completely so that there will be a complete record, which is similar to what you said, but
Right, because he felt like, let's get the facts out, let's get this record, so if I make a ruling, which it will probably be appealed, the Court of Appeals will be able to decide, because the law is murky in this area. So when that happened, the parties then went to a judicial settlement conference, and this is where this is where my client has an issue. She agreed at this judicial settlement conference to allow Starr Potts to be a parent, meaning that she agreed to a parenting plan where Starr Potts had parenting time and she was obligated to pay child support. It is unclear by the record whether the parties agreed for Starr Potts to be placed on the birth certificate, because it wasn't part of the agreement. And to be honest, my client doesn't even remember how that happened. But the judge placed Starr Potts on the birth certificate as a mother. So I get the case. Within a year, I filed a Rule 60-02-5 motion trying to set aside the designation of Starr Potts being a parent. And the argument is that the court did not have subject matter jurisdiction as it relates to standing. So Starr Potts did not have standing to say, I want to be a parent. So I filed the Rule 60-02-5 motion with the court and had an argument, and the judge denied it. And he stated that the paternity statutes were gender neutral. Therefore, he applied the fact that the children were held out as the children of Starr Potts. Therefore, there's paternity there. And then he also stated, I'm sorry, maternity. I guess we can just say maternity. And then he also stated that because the egg that was placed in my client was a donor egg, that the statute says that Starr Potts was an intended recipient parent, therefore it made her a parent. Now, that is wrong, in my opinion. I believe that using the abuse of discretion
wasn't it the embryo that the judge said was separate from the donor egg, because the egg itself wasn't viable until there was the gametes and combined with the egg, and the embryo is what was implanted into your client. And I think the trial judge found that important.
Right. And what I said is that the statute does not define what a donor egg is. That was the interpretation that the judge had made. But what the American Society of Reproductive Specialists says is a donor egg is an egg that comes from a different woman and then is implanted into another woman. That is not what happened in this case.
Are we permitted to consider that? Is that medical literature properly admitted into evidence in this case?
No, it was not. It was not admitted in the case. However, the statute was void as to what that definition is. So the court made the interpretation in his order what a donor egg was. There is no statute that defines what a donor egg is. There is no definitions page that says this is what a donor egg is. The court had taken liberty with that particular definition and did not cite to any literature, any medical definition or anything when he made that determination that that donor egg was a donor egg. In my brief, I had cited to the definition that it's just defined as, according to the people in the industry, and using the ordinary plain meaning of terms as required when interpreting statutes. I believe that the definition should be what the definition is in that particular field. but there is no
Let me
definition.
pose a question to you, counsel, and it's totally different than what you and Judge Clement are talking about, but is standing waivable in this case?
I don't think that standing is waivable in this case because standing is interwoven with subject matter jurisdiction. So subject matter jurisdiction cannot be waived. So if you don't have standing, you
True.
don't have subject matter jurisdiction. So I don't think you can waive it.
Well, what's different now than when your client agreed to whatever your client agreed to and the agreed order was entered with the court?
Well, I can tell you this, there is nothing, as far as factual things, there is nothing different now. But the issue is not about the time passing, it's about whether it is legally liable for a court to make someone a parent when the law does not give them the standing to ask.
Well, I
So,
think it really depends on whether standing is waivable.
right, and I don't think that it is waivable because it's intertwined with subject matter
Do
jurisdiction.
you have any case law that, anything similar like this that says that you cannot waive standing?
Well, in my brief, I did cite to a case that said that standing is intertwined with subject matter jurisdiction. But as far as a case like this, where they say that standing is waivable or not, there is none because there is no cases. So the only thing that I can do is extrapolate to what the definition of standing and how it relates to subject matter jurisdiction. So it's the law that standing and subject matter jurisdiction are intertwined, and you have to have not only the issue that the court can hear, but the person also has to have a legal right to bring it to court in order for there to be subject matter jurisdiction.
Ms. Wade, why doesn't Tennessee Code annotated 362304, that's the one about holding the child out as a natural child,
So,
why doesn't that resolve the standing?
okay, so in that, so I did make this argument first. We're dealing with a paternity statute. So the number one thing is that that is a paternity statute, and this is not a paternity case. Another issue is that
Why isn't it a paternity case?
because Starr Potts is she's not a man, she's a woman. This is not a case where we're dealing with a woman and a man. We're dealing with a woman and a woman. And in Ray CKG, when the Court of Appeals made the woman the mother, it clearly stated
So
that
your position would be that if this was a dispute custody battle between a woman and a man, and the man was claiming that the woman wasn't the parent, but the woman said, but I've held this child out as my child, you're saying that that woman wouldn't have the right to do that?
no, I'm not saying that. I'm not saying that. What I'm saying is that,
It sure sounds like it.
well, I understand that if a man was in this particular situation, I think that's what you're getting at. If a man was in this particular situation, that he would be allowed to be the father versus, because it's two women in this situation.
So your position is Judge Robinson was wrong to say that men and women should be treated equally.
No, I think that men and women should be treated equally. The issue
Sounds
that
like you're saying no, because this woman can't be treated the same as a man in a paternity action.
well, let me say this, that in the issue about holding the children out as your own, you also have to comply with 36.4, I believe it's 211, when you are making a establishment of paternity based on that. That did not happen in this particular case. All we had in this particular case was an agreement between the parties at the final hearing saying that the children were my clients. Unfortunately, if you agree to paternity, even if the court orders it, paternity has to be established pursuant to the statute. And in this case, it was not done at all. The only thing that we have is an agreement between the two parties. Now, going to your question about holding the children out to be Starr Potts, there was never a hearing about that. That's what the judge wanted to do. The judge wanted to have a hearing to see if it could even apply to this particular case, and that had never happened. The decision about my Starr Potts being a parent to these children only came about as a result of my Rule 60 motion. It was never determination by the court prior to my Rule 60 motion that was even the case. It was just in response to mine because the judge refused to rule on that issue when it was brought to his attention when they initially started litigating this case at the first time.
What about if the mother, they're both mothers, if Starr is on the birth certificate, doesn't it flow from that she should have rights to visitation and other things?
Well, the Starr Potts being placed on the birth certificate was as a result of the judge's or the agreement. So it wasn't like a voluntary acknowledgement issue where she signed the birth certificate in the delivery room. That came simultaneously with the final order giving her parenthood status. So I don't know if the birth certificate, it's like putting the chicken before the egg. She was placed on the birth certificate as a result of the agreement.
Yes, but doesn't the U.S. Supreme Court case of Parvin versus Smith basically say that same-sex and opposite-sex couples have to be treated the same way under birth certificate statutes?
Well, I agree. However, this is different because the mother's name being placed on the birth certificate was as a result of the agreement. Typically, when you have two different sex people and they place their name on the birth certificate, usually that's not done as a result of a court hearing. That's already done before you walk into court. And so when two separate sex people have children and they're on the birth certificate, the law does say, hey, you have already acknowledged paternity, therefore you should be deemed to be the parent. However, that's not what happened in this case. There was never an acknowledgement.
But my question is, doesn't the law require that Starr be placed on the birth certificate? And if she is, then she should have other rights that flow from being a parent.
If a parent is on a birth certificate and there is not a challenge to the paternity of that parent, then that parent, until the challenge is set aside, does have parental rights to that child. I do agree with that. But in this case, we are contesting that particular order. And at this point, she is a parent. But what we're trying to do, which heterosexual people can do, they can come to court to try to disestablish paternity. And that's exactly the same thing that we're trying to do in this particular case.
All right. Any further questions? Hearing none. Thank you, Ms. Wade, for your argument today. We will take this matter under advisement. Mr.
Thank you. Thank you.